Welcome to Divcasts from the University of Chicago Divinity School. For more of our podcasts and information about our terms of use, please see our website, divinity.uchicago.edu/podcasts.
Welcome everybody to today's Wednesday lunch here at the Divinity School. It's our first lunch of the quarter, so happy 2015. Thank you all for being here. Before we get started, I want to do our usual housekeeping. And first of all, I have to thank I believe our chef for today was Blair. Blair and our crew who made this meal from scratch. So thank you guys. You clean up after yourself. So on your way out, if you could put are these plates compostable? Yeah?
Yes.
So put your plates and your leftovers and your napkins into the compost, and I guess there's no real garbage. If you have other stuff, put it in the garbage. And put your silverware into our yellow soapy vat. That helps the crew out a lot. So we have a great Wednesday lunch quarter. You can sign up for the entire quarter if you want to. Email divinitylunch@gmail.com, or you can go quarter by quarter. Week by week. The camera captures everything. Next week we have a student, Damon Romer, who's an MA student here, and he was recently awarded a community accelerator project grant for his organization, which works on teaching Woodlawn kids coding. So please sign up to see your peer next week, and check our website or check our electronic stuff for other Wednesday lunches throughout the quarter. Are there any community announcements today? Dean Owen?
Yes. First of all, tomorrow evening at 6 p.m. at Rockefeller is the university's annual Martin Luther King Jr. holiday observance. Reverend Jesse Jackson Sr. will be the speaker, and I will be introducing him. So it will be great to see some familiar faces there for that. You may have noticed I sent out a note on the second floor on the Marty Center bulletin board. There's a huge poster. The theme this year is what does justice look like, and communities all across the campus are being invited to think about the investment that you will make into what Dr. King referred to as the vault of opportunity in this nation, the bank of justice. So some students have already written sort of on this promissory note, and we took a picture which will be shared as part of the presentation tomorrow night at Rockefeller. So thanks to those students who came out for that. So that's that. Also, next Tuesday at 4:30, Alex Rockland, who's a recent graduate in the PhD program in History of Religions, will be doing a mock job talk for an on-campus interview that he has at Grand Valley State, and we're trying to arrange another one for peer Julianne Harcher. So when you see these announcements about job talks, it doesn't matter what program you're in, if you're PhD, MA, whatever. If you're interested in the academic job market, you want to see what this looks like, this process, particularly those of you who may be earlier on in your PhD programs. It helps support your classmates to have you there to listen and provide feedback, but it's also good learning for you as they engage with the faculty who are there. So next Tuesday at 4:30, I'll be sending an email around about that. But in this season, we may be doing some of these things ad hoc as people get interviews. So if you're able to come out and support your fellow classmates, it really means a lot to them to have students in the audience. So that's all I have for now. Also, tomorrow, deadline for PhD internal petitions.
Start tonight.
Yeah.
Anybody else have a community announcement or workshop or Blair?
This quarter's Women's Caucus tea times will be Fridays, 1:30 to 3:30 in room 201. So all women are welcome, and yeah, we'd love to see you.
Is there free food?
There is free food.
Don't forget to mention the free food in your announcements. Elizabeth?
So tomorrow, the Islamic Studies workshop is having a Sunday. We'll be talking about Islamic feminism in Kuwait. And so that's at 4:30 in room 201, and there will be food instead of drinks.
This is the first 101 of 2015. We're in our third year now, so if you see, to save time, I put it on a tiny piece of paper, the schedule for the rest of the 101s. All of those will not be here, but will be at the Disciples Divinity House at 7 p.m. So you'll be getting emails about those, no doubt. If you have any further questions, or if you'd like to present a 101 yourself, come up with me afterwards.
What's a 101?
A 101 is a no prior knowledge, sort of casual, we take our shoes off time in which one student talks about something they know a lot about, usually with very little preparation, to a bunch of students who know nothing about that topic for a short period of time, and we drink wine. So there will be free wine.
So you can see the crossover between the 101s and Wednesday lunch. Last year, well, I guess it was last year, it was 2014, Russell and I decided to try 101s at Wednesday lunch. We also have wine. We're also a friendly atmosphere. I don't know if we're in a room full of people who know nothing about the topics. I do notice several students over here. So our speaker for today is a PhD candidate here at the Div School, Gutmann. He is writing a dissertation titled Traditions and Progress, Islam, Confucianism, Modernity. So the 101 for today, as you can see, is about Islamic law. Tim is going to address Islamic law in terms of its history and development, basic norms and styles of reasoning, and continued relevance in the post-colonial world. So turn off your phone noise things and join me in welcoming Mr. Gutmann.
Good afternoon. Thank you so much, Taryn. I also want to thank Russell for the invitation to be part of this very exciting teaching experiment. Looking at the upcoming schedules on the tables, I am very eager to return to the audience for a number of these presentations. Liberalism is a tradition of laws. To account for political difference today in the city, in the country, relies on some basic ideas of what the law is, what force it has for and from whom, how it makes equivalences and distinctions among persons, states, and others with standing and with rights. Today, such basic assumptions extend far beyond the United States into our assumptions about how a nation constitutes itself, how it can be said to be solvent or not, the degree to which it presents legal fact or legal fiction. In context of this introduction, I point to these basic assumptions because all of this is in the back of our heads when we hear the word law. And from this particular perspective of law that is imminent to us, we're going to meet a tradition with very different senses of what the law is. Though much of its distinctive vocabulary has been absorbed into English, in a process that suspends the traditions we're going to be discussing, that of fiqh jurisprudence and the Sharia, in the matrix of modernization, which is the final question we'll examine in thinking about religion and law in the present moment. So I'm organizing this talk around questions. Questions are very important in Islamic law because they are the originators of precedent in a very fundamental way that we are going to look at. I've chosen the number 4 because 4 is very significant in Islamic law. There are 4 greater Sunni schools of jurisprudence, and there are canonically 4 sources for an authoritative ruling on a question of law. So those questions we'll be asking today are, how have Muslims tended to use words like Sharia and fiqh and literal and morphic derivatives of these 2 words? This, of course, does not use the word law, and I am assuming that they can be translated to something important in the legal realm, which is, of course, an assumption that no Introduction to Islamic Law textbook is complete without beginning to question. Of course, the inadequacy of translation is a familiar problem to all of us, but I only submit that these 2 words are the closest we get to the ideas and words that law represents in the English language. The one other possibility, if you put law into Google Translate in Arabic, qanun, as some of you might be doing to contest me after the talk is finished, represents a very different tradition entirely, which we can discuss. The second question we're going to be asking is, what norms have these terms tended to include? Law is normative. It's certainly not the only way of talking about a political norm or a personal norm, but the normative aspect is going to be essential to any understanding of what a law is. How did Islamic law develop historically is a question we're going to ask with attention to Western scholarship, particularly to what some of your colleagues will have been introduced to the questions of Islamic law, which in the field largely are historical, which is why almost all of the work in Islamic law at the university going on right now happens in departments like Near Eastern Languages and Civilizations rather than the Div School, the Islamic Studies Committee here. And last but not least, what may seem like an obvious question, but one I want to put into a broader perspective, a few centuries of perspective away from the present moment, is why to talk about Islamic law today. Certainly, public controversy is always attached to topics, well, recently attached to topics of Islamic law in the West, and we're going to look at some of the historical roots of how those questions emerge and how they acquire their distinctive salience. So to talk about the first question, how have Muslims tended to use words like Sharia and fiqh, I want to look at two particular verses of the Quran which use the word, either use the word Sharia or use its triliteral root shara'a, because the reference to the Quran is basic for lexical and devotional purposes alike, and the translations are all mine, so this I bear responsibility for what I'm going to present. So as always with the Quran, we remember that the voice is that of the divine, and the address is immediately to the Prophet Muhammad, who died in 632, who Muslims believe culminates the legacy of prophecy that includes the prophets of the Hebrew Bible and the Christian Testaments. And the word prophet is used in a distinctive way for Muslims. So the verse says, "We have made you a Sharia of commandment, so therefore follow it, and do not follow the whims of those who do not know." So the law has a divine origin, it is directive, but it is dependent on, it is linked to, rather than dependent on, it is linked to a concept of knowledge. Those who know not cannot direct law. And we're going to look at specifically what this idea of knowledge from the triliteral root of alama, which is here ya'lamun in the verbal form, what this particular norm of knowledge is and how it is understood to constitute the legacy of jurisprudence. So from this, we see a fundamental linkage that is in many ways repeated and reconfigured elsewhere in the Quran. So the second use of the word shara'a is quite a bit longer, but certainly in a more famous context. The previous verse I showed you is the only use of the word sharia in the Quran, spelled out in precisely that way, though the root appears many, many times. And again, this is in the divine address. "I sent down to you a book of the truth, confirming what at hand of the book, what was at hand of the book, and preserving it. So judge among yourselves by what God sent down. Do not follow whims of them, avoiding the truth. For each of you we have made a shara and a way. If God wished, he would have made you one community, but he tests you by what he gave you, so compete in good deeds. To God you will all return, and he will inform you about what you have differed." What I want to point to is, of course, the use of shara and the use of the word each. As Professor Sells would want, I am not going to determine your interpretation by saying which different persons or communities are meant by each, nor who specifically is meant by you, though the legacies of Islamic jurisprudence believe these to be the groups kin to Islam in historical and religious terms, that being Jews, Christians, and other groups that have, in practical terms, been extended to most world traditions, which we'll talk about in the historical section. So in the first, we saw the directive importance of shara, of Islamic law, of the Sharia, and in this we're seeing a descriptive element. Each community has a law, and for each community, the law is a divine standard. These verses are, of course, in tension. If there is one particular expectation, or if there is many, is not something that is precisely resolved by merely putting these side to side. And the tension of this arrangement is set up in traditional Islamic rule, a system of political governance that sees laws being particular to each community, and in certain matters invited, in certain matters deferent to the particular standards of the community, and not for the governing Muslim majority or the governing Muslim power. So a descriptive and a prescriptive element to this sharia. The last verse we're going to look at deals with the letters faqaha. I wanted to give you something with fiqh in it, but yafqahun is as close as we're going to get in a moment. So in the divine voice again, it is he who made you of one soul, and thus a place to set you and a place to return. We made signs finally for people who discern, and the alternation between first person singular and plural is reflected in the original. It's often interpreted as something like the editorial we. So discernment is a key issue here, which gets us to the literal meaning of the root shara'a, which pertains to a way, which pertains to a road, which pertains to a direction. In modern Arabic, a shara is a street, such as you'd find in most city addresses. The most common places to live, apart from the broader avenues or the smaller ways or alleys, a shara is a street, occupying a similar semantic range to the Chinese dao, which also means way. That is of particular interest to me, possibly of you, that in Confucianism is also linked to a notion of orthodoxy. It is also linked to a notion of straightness. The straight path, the sirat al-mustaqim, is a very common phrase that occurs in the Quran and can be connected to the Sharia in a number of particular ways. But discernment of signs wends the way. It discerns the particular way. Staying straight on a path that is neither excessive nor lax. A middle way concept is also important in this notion of Sharia. Another word for road is tariqa, which reflects Sufi use, which is quite, though the words can be in many senses interchangeable, in very common basic use, reflects something very different than the tradition of jurisprudence, which is interested in pursuing the mean, interested in pursuing the majority, in facilitating affairs, which is not a mystical goal. So what norms have these tended to include, these particular vocabularies and the traditions that developed them? In the classical Islamic legal system, the law is represented by two separate but equally important parts. That we're going to learn about the muftis who interpret the law and the qadis who exercise enforcement power. These are their stories. First, we're going to talk about norms of conduct and norms of authority. Before we do that, I want to point out, of course, that this can be difficult for us because we belong to a world of parliaments and a world of police. We belong to the contemporary world in which law is not a law without law enforcement. Law is not a law without application of powers. This is an understanding basic to the Constitution, something that came about before modern police forces, and is distinctive to the Enlightenment, a tradition that departs significantly from an understanding of law that preceded it, of which Islamic law, classical Islamic law, is one particular instance. So while this link of conduct and authority is not a disjunction in classical Islamic jurisprudence, the concepts connect very differently, as we'll see. So much of the idea of being equal subjects under law remains outside of the judiciary realm. So effectively, it is not a matter of law enforcement, which is something I want to define specifically as we go. But if you can remember that these can be not disjoint, but differently connected than we're used to in the contemporary world. So in terms of the norms of conduct, an authoritative pronouncement that is respected is called a hukam. It's from a word that means wisdom, and to speak of the rulings on a subject, to speak of the general juristic thought on a subject, is to speak of the ahkam. This is not an English word of the subject, though hukam is, reflecting a distinctive downward look at the Islamic legal tradition that we'll get back to later. Among permission and prohibition, there are classically 5 categories of acts in Islamic law. There is that which is obligatory, which deals mainly with the acts of worship that are obligatory upon every individual, and other acts such as judicial knowledge and the waging of jihad, which are obligatory of the community as a whole, which is to say not each individual. The 5 pillars, the classical 5 pillars, deal with worship, which we'll discuss below, among other obligatory acts. Encouraged acts, such as supererogatory prayer or supplementary fasting, are beloved or mustahab by the divine. Of course, keeping the 9th and 10th Amendment in mind from America's Constitution, most fall into the category of neutral acts, carrying neither disreward or blessing in the divine accounting and the divine reckoning at the end of life. And neutrality is something that is something that can intersect with both obligation and prohibition. So, for example, an example often used by many teachers, such as Professor Shamsi, Ahmed Shamsi in the Department of Near East Languages and Civilizations, if one skips out on prayers, which is forbidden, to contract an otherwise legal sale of a legal good and to do it according to Islamic contract law, the sale stands. One's skipping out on one's prayers is considered to be distinct, even though the actions themselves are not. One couldn't have bought the otherwise legal thing if one had not skipped out. But this is an example. The sale is neutral. It's valid. It stands. There are discouraged acts. There are reprehensible acts, blameworthy acts, and significantly, I think the word that is received in English is the prohibited, the haram. The bearing of the consumption of interest, the consumption of pork and wine and so on, that are well known, but also that belong to a rubric of accounting in terms of repentance that connects to the discouraged acts. The haram is, in classical Islamic law, the closest one could get to the realm of judicial or juridical enforcement. This is a realm of a market inspector or muhtasib who pursues equitable dealing in the marketplace, something that's not alien from European medieval marketing conventions. And this also, haram acts are what are most likely to involve something that is closest to the English word trial, the approaching of a judge, which we'll discuss. So let's talk for a moment further about the norms of conduct. Conduct divides into 2 categories, conduct in worship and conduct among people generally. And in terms of the conduct in worship, which is the first part of a legal compendium or muhtasar, individual obligations include the 5 pillars, all of which are English words. There's the profession of faith, or the shahada, the 5 obligatory prayers, or salat, the giving of alms annually, or zakat, the fast during Ramadan, and the once in a lifetime, or at least once minimum, pilgrimage to Mecca and Medina, the Hajj, which is incumbent upon those who can. So let's talk about the more complicated, the more divvy question, the concept of authority. What is juristic authority, and what is an authoritative opinion or a fatwa? And the way to begin the complicated answer is that authority resides with him who's asked. The gender reference here is intentional, as the assumption that Legal authority is particular to men is a normative assumption in classical Islamic law and in the Islamic world today, although many scholars have broken significant ground in recent years and asserted that this is nowhere spelled out, nowhere determinatively explicit. A question that is very much open and very much contested. So one asks one possessed of knowledge of revelation and prophetic tradition about a matter of law. For example, what is a valid form of worship? What constitutes equitable dealing in business and contracts? What is proper for marriage and divorce? And what exercises precedent in determining these matters? Which particular source of law is open and is pertinent to this particular question. So this is the first kind of authority we're going to discuss, and we're also going to discuss a kind of authority that is not particular to the giving of fatwas. One who gives a fatwa is mufti, another English word, and one who serves as a judge is a qadi, discussed below. So first we're going to tackle the first of these questions about juristic authority. So a fatwa decides the precedent of an authoritative source, which is either revelation, traditions pertaining to the actions, speech, and dispositions of the Prophet Muhammad, and what depends on these. And each judgment, each fatwa comes from the perspective of a particular jurisconsult, a particular mufti, according to the terms of the particular inquiry. This may be done anonymously. No mufti ex officio has ever enforced what he judges. This is not in the office. And there is nothing to prevent one from getting a second opinion, which is, when we contrast with the gravity and the power of the judiciary, it may be counterintuitive to English speakers, to contemporary people, to think that this is where authoritative precedent resides. It resides with fatwas rather than with judgments. It does not reside with, effectively it resides with legal briefs, with counsel, rather than with decisions, which is the reverse, of course, of the English common law idea of precedent. So what does it mean to serve as a judge or qadi? You may know the word in English qadi, and you may also know the German word Justiz from Max Weber, which is like the term Alperin or Hokum, a pejorative term referring to judicial arbitrariness. Weber draws a memorable picture of the savage under the tree, consulted about arcane and inconsequential matters, and pronouncing with the arbitrary vigor of the unenlightened. With whatever Weber laid down as a dean of modernity and modernization studies, he was not speaking there as an Islamicist, because the concern about the arbitrariness of judges is classical in Islamic legal tradition. In fact, it's what demotes the office of judge from the precedent-preferred position of a legal scholar, of a jurisconsult, of an alim, of a mufti. This is expressed most pithily, most memorably, in the terms of one of the founders of the classical Islamic law schools, Nu'man ibn Thabit Abu Hanifa, who said that the burden of a judge is a burden to be avoided if one possibly can. Most of what judges deal with this is open to significant questioning in scholarship, as judgments are written down far less frequently than fatwas. Judges are appointed by an authority, a sultan, an imam, a khalifa, a caliph. There are a number of vocabulary pertaining to political authority, and they exercise facilitation of the Sharia in public controversies, which is to say, suits with respect to crime, with respect to what we would call crime, murder and theft, are brought to a judge and are almost always resolved, or are classically resolved by witnessing, or shahada, which is also what we heard from profession of faith, which is the certification, the verification of witness of an upstanding man in the community, possessed of capacity, possessed of probity, open to public scrutiny, the service as a public witness is linked to the judicial function and is a kind of classical law enforcement, a kind of pre-modern law enforcement that is passive in the sense of cases are brought to him, they are brought to the witness and to the colleague. The fear of corruption, of personal loyalty, of breaking of the legitimacy of the bounds of the community by an authority being seen to flout the Sharia are some of the tensions that weigh upon a qadi and are not seen to weigh upon a mufti, who is seen as a scholar at large, who is seen as one possessed of freedom and resources to research and to pronounce authoritatively on precedent, which is not a freedom open to a qadi, at least not ex officio. And of course, in practice, these offices overlapped considerably in the Western Islamic world, in Spain and Morocco. It was common to have something like a grand jury of jurisconsults inform judges' decisions to assure a greater legal gravity to their particular rulings. So on to the third question we have, which pertains to the four great Sunni traditions of law that and legal thought and legal practice that come down to the present. The first is the Maliki school, which is most prevalent in West Africa as the historical school of Andalusia, which is started by Malik ibn Anas of the Hejaz in Saudi Arabia, contemporary Saudi Arabia, which centers around the practice of the community, which is to say, which centers around the precedent of the people of Medina, the first capital of the Islamic Caliphate, the first capital of Islamic rule, the city that received the Prophet leaving Mecca in the Hijra, the beginning of the Islamic reckoning of history. This particular community, by lineage and by descent, is said to be closest to the Prophet in the 8th century, the time of Malik's writing. And to distinguish these particular legal inclinations is not to say that today they are split by differences in philosophy and differences in concern. There's a lot of cross-penetration, a lot of regularizing that has brought many of these different schools into practical communion on many of the methodological issues, and what divides them are, in at least today, styles of ritual concern, issues of particular precedence of particular authority figures, among others. But by and large, these recognize each other as valid schools, as valid legal regimes, and it was not uncommon for a classical Islamic state or a classical Islamic government to maintain multiple jurists and judges loyal to these particular schools. So the second school, started by Gutmann, that of Abu Hanifa, who died in 772, predates the first in the sense that the founder died before Malik died. However, it takes the name the Hanafi school, but there's really a co-founder of this school, Abu Yusuf, Abu Hanifa's student, who resided with him, who studied with him, who developed his thought in Kufa, a town in contemporary Iraq, that formed around the core idea of the ratio legis, the idea of the reason of law, which was about discerning the weight of particular opinion, of repi, of a particular opinion as being more or less grounded in authoritative precedent. So this is an example of the reasoning of ratio legis is that consumption of alcohol is prohibited. This is a normative belief among Muslims in terms of the Sharia, although only one particular kind of alcohol is mentioned in the Quran. The intoxicating property of alcohol in the context of traditions reported of the Prophet and his concern with discipline, with preserving harmony extend to anything that alters consciousness. So the prohibition of intoxication is by reasoning in this way. The third major jurist is Palestinian Hamad ibn Idris al-Shafi'i, and died in Egypt. And his reflects a synthesis of these different approaches I'll discuss in the next slide. His also represents a turning point in Islamic legal history when the literary format and research constituency of the profession of the law, the profession of being a mufti, changed to suit particular terms set out by a Shafi'i that we'll discuss. The last, removed a little bit in time from the others, Ahmed ibn Hanbal, represents a devotion to tradition, to the literary historical accounts of prophetic action and word as the most fundamental source of law, which is to say that reasoning from these and deriving principles or precepts from them are to be suspiciously regarded in general. And accordingly, what Hanbalis accept of authoritative records of the Prophet's deeds and actions is considerably larger as a result. To introduce very briefly the Western scholarship on Islamic law, it has tended to turn around the question of, is a Shafi'i the greatest of the great? Is a Shafi'i's grand synthesis, this is the term that is used by Joseph Schacht, the turning point in Islamic legal history? Was this when, to use the words of Ahmed Shamsi, when Islamic law became less of a tradition and more of a law in and of itself? A Shafi'i's synthesis is to take the authoritative sources of Islamic law, the Quran and the traditions of the Prophet, the Hadith, the Sunnah, and read them not in terms of each other, not have them criticize each other, but in terms of themselves, to be mutually defining and co-constituent, to favor, if a clear pronouncement is not found in one of these, analogy with a valid and clear directive from either, and lastly with one's reasoned opinion, a ranking of 4 sources. This is how Schacht interprets a Shafi'i, and this is open to considerable debate. What Professor Shamsi maintains about this particular moment in Islamic history in Cairo is that from this moment on, one is not bound to a geographical school. One is not bound to Kufa, one is not bound to Medina, one is not bound to Cairo or another center, because the research of prophetic traditions is something that needs to connect the whole of the Islamic world. It's a profession that needs to be undertaken by cosmopolitan men, meaning that these men gain in authority and in status. The further they can go, the further they can learn, the further in terms of the original Islamic conquests and the biography of great transmitters of tradition that they can research. And this, in Professor Shamsi's view, is laying the groundwork for what Islamic law would become, which is very much a cosmopolitan tradition. A mufti is certainly gains in authority with travel, a topic discussed extensively by my colleague Nadia Khan, and the parochializing of Islamic legal tradition is over, effectively, in his view. There are other readings. There are readings that the view taken by Malik ibn Anas of the precedents of Medina has some community thinking sense to it. There is considerable note that Malik did not reject reports of the Prophet that came from outside his favorite sources. He only said that what is known of the Prophet and survives from that time must in a certain sense work. He is not rejecting the historicity of other people's views, but saying that they have not constituted the foundations of a working community, and a working community invested in the legacy of the Prophet as Medina is seen at his time. This is a view propounded by Omar Farouk Abdullah, and in further contrast, there is a view by Jonathan Brown, that maintains that it is a Hanbali conscience, a regard for the traditions of the Prophet, for the Sunnah, a deep and thoroughgoing concern for the authenticity of these traditions that is the spirit of Sunni Islam. And without this Hanbali school, which is the smallest of the four, this would not be realized. So this is, in brief, Western scholarship on the topic. I'm going to go as fast as I can through the last and hottest question. So why would we talk about Islamic law today? What I just discussed is a historical debate. It's a cloistered one. It's one removed from the present with the shrillness and incommensurable absolutism of public discourse of Islamic law on the Muslim question. But why talk about Islamic law today can be reformatted in a general question. What does a nation state, which is a secular formation with a very distinctly religious cast, need with an uncodified religious legal tradition? I hope that's another way of asking the question. The first Muslim worlds, the first modern nation states in the Muslim world emerged from the colonial frameworks of the 19th century. And these frameworks tended to affect a hard partition of the public sphere and the private sphere that was being fiercely contested in the West at the time, of course. Penal, civil, and commercial law throughout the Muslim world today tend to keep the lineaments of French and British rule. Public spheres designed for imperial supervision, designed for international legal standards, so to speak. While matters of personal status, those of marriage, divorce, inheritance, and custody, were considered a private sphere left to native traditions. The best examples of this are India's Anglo-Mahometan law and the Indigena Code of French Algeria, in which the private sphere of religious devotion, of the family, of women, in other words, is to be left to the native traditions. One needs to extract certain things from the efficient running of the colony. One needs to expect a certain standard of public propriety, but within the bounds of a man's own home, his own business can be left to his particular religious disposition. This being, of course, the British formula from the Reformation that achieves global significance in the colonial era. So today, mixes of legal Shari'i rulings are codified and enforced by various Muslim-majority governments, which is a conscriptionist and bureaucratic process that was unknown to traditional jurisconsult. The idea of a mufti being the authoritative pronouncer of a particular law, open to second opinion, open to debate, is gone. The decision rests with Parliament, it rests with the security state, it rests with particular interpretations of the Sharia favored by the government, favored by and enforceable by modern methods. So periodic Sharia panics in the West and ongoing controversy about the liberality or constraint or the historicity or fraud of Sharia measures in Muslim-majority countries thus share common structures of modern understanding of a citizen subject to and constitutive of the nation state, in which the definitive private matters of religion emerge intermittently in public. And one does not need to be a Marxian to see here parallels to the Jewish question, the woman question, the queer question, formulated as many have as the Muslim question today. There are a number of books under this title. It's a subgenre of post-colonial studies. In the friction of the public sphere and the private sphere, in the separate spheres that cannot help but interact. So to recap, the four questions we asked today: what norms have governed the definition of the way and the discernment of the way? How have they been descriptive as well as prescriptive? That Islamic law is a divine command, but it in some measure is not a universal one, because there is a recognition in the Quran that there are other divine commands, there are other divine shara. What norms have these tended to include? What distinguishes the authoritative counsel of a mufti from the executive juridical action of a qadi? How had Islamic law tended to develop historically? It tended to favor the routinization of judgment and the cosmopolitanism of research on the traditions of the Prophet. And why talk about Islamic law today? So on this last question, we were discussing the contemporary world, where ways that the law binds communities have to do with the boundaries of the nation state, where questions about authority are inseparable from questions about power and rights of force. And To not go too far, I want to stress that these gravities are not alien from traditions of Islamic jurisprudence, but the perspectives I've tried to introduce are very distinct. The distinction I want to end with is the connection of legal authority held in transmission with the idea of counsel. Counsel in Islamic traditions doesn't necessarily have the sense in which it's referred to in law and order, legal counsel being the anticipation of a trial or the conduct of a trial, but the conduct of life subject to one's fellow believers in a public constituted by it. Thank you very much.
We can take a few moments for questions.
You mentioned Sharia scares at the end, which is a question I have. You'll hear every now and then in the news that a leader has the goal of setting up Sharia as normative for a government. What is assumed in that, and what is there a misunderstanding at play in that? You mentioned a little bit about this, but I'd like to sort of, when people bring that up, what should we question or what should we say?
Thank you. The scholar at the bottom there, Wa'il Halak, has articulated a particular formula for this and is generally assented in the field, which is that when a contemporary leader like Tayyip Erdogan or Omar Ibrahim and so on, to give two very different examples, talks about implementing the Sharia or enforcing the Sharia, it almost always means a rectification of that zone of personal status, marriage, divorce, and custody with what a state vision of authoritative precedent is, as well as a modernized idea of the office of the muhtasib, which we mentioned as the market inspector. In northern Nigeria and Saudi Arabia, this comes under the framework of the prevention of vice and the promotion of virtue, or the promotion of virtue and the prevention of vice, which is to grant latitude to a special kind of police to monitor religious norms, most commonly associated with the conduct of women. Those cases reach the Western media the loudest, but also in terms of assuring care for the vulnerable, for the elderly, and for children, which intersects the police state and the welfare state in ways that are invoked in this demand for Sharia and are almost never quite explicitly thought out. As in, there are numerous attempts to Shariaize existing secular laws, and they never satisfy it. So this cause is very successful, particularly in non-democratic contexts.
Hi, when Mufti issues a fatwa, what's the fatwa supposed to apply to? Is it to the Mufti's specific community or all practicing Muslims?
That's a good question. It applies to the question itself. It is the Mufti's judgment of what is to be done. Presented a set of circumstances that he is presented. An example could be about the validity of skipping a particular ritual ablution, a particular way one is supposed to clean oneself before prayers, for the reason of travel, which most jurists agree that if one is traveling, the requirements to pray are lessened by the intensity of travel, and if presented a certain set of circumstances, I was stuck in traffic, my plane was very late, it was hot, it was uncomfortable, I was unable to perform adequate ablutions to have this particular act of worship, this particular daily prayer incumbent. Does this count as extremity of travel or excess or undue burden, in other words? And the Mufti is just supposed to look at those circumstances and say whether this person has to or does not have to commit the particular act, such as one of the daily prayers. And that is open to a second opinion. Muftis are not seen to have constituencies in the pre-modern times the way qadis do. So it's supposed to be particular to the particular the question.
you mentioned several times that the word Sharia, I'm probably mispronouncing it, relates to street or way, and I'm reminded of via in Latin, and as in ego sum via, vera, vita. So it seems there's some kind of commonalities there. Could you comment on that?
There's Dao in Chinese, and the greater way in Sanskrit is, it's not Sangha. Sangha is whole community, right? But crowdsourcing. I remember that way has or street or road has a particular significance in Buddhism also. I'm not sure. It's a fascinating thing to think about. The interesting thing for me in Confucianism is the way that the straight path of transmission is expressed as a street, as the Dao Tong is the orthodox Confucian tradition, which is response to the word Dao. That's probably familiar to most of you from the Dao De Jing, the classic of the way and the virtue.
Thank you.
I'm just curious that the enacting Sharia law, on the other hand, of when Westerners bring up this and warn that Muslim immigrants are going to try and enact Sharia here in the United States, for instance. I was curious what you think they are referring to, because I think they're clearly not referring to what you described.
There's a mix. There is the particular sensation addressed to the religious police in Saudi Arabia, to the particular political criticism they receive both within the kingdom from international human rights groups and so on. The same with the religious police in northern Nigeria, alongside some more parochial cases that are usually the casus belli of the contemporary controversies. In Canada recently, there was a move to introduce licensing of Muslim divorce counseling, which is basically to conduct a divorce according to what a Canadian board of Islamic scholars deems to be Sharia principles, particularly pertaining to guarantees of restoration of property to each party after the divorce and custody, and presented that Muslim couples who wanted to divorce in this way could visit one of these licensed professionals and have an agreement presented to a court that they both signed. This measure, innocuous as it is, I mean, anyone can counsel anything. If there's a contract, its particular divisions of property under the Canadian divorce laws, I understand it, are subject only to the mediation of the couple themselves. If they want to divide things a particular way and both sign to it, then that's what it is, and there's no need to go through the rest of contested divorce procedures. This sparked a Sharia panic in Ontario, and while divorce mediation in Christian and Jewish traditions and in non-religious contexts is recognized, Muslim divorce counseling, specifically so-called, is not. So when these happen, the graphics of the Saudi religious police and the questions about the legitimacy of an Iranian leader's election, or the use of the cartoon character's religious profession flash on the screen, and the casus belli in the West is very often these personal status questions, in the same way that it is in the Middle East and Muslim majority contexts.
I think if there's nothing else, we're out of time anyway. So thank you.
We thank you for listening to or viewing our podcast. For more information and for other podcasts, please see our website, divinity.uchicago.edu/podcasts. Copyright, the University of Chicago Divinity School.